Just wanted to touch on a couple of things first that the other speakers have talked about, because there's no doubt that you in the regulated sector are facing a double whammy, if you like, of regulation. You already have your principle 3, which is failure to maintain systems and controls generally, which doesn't obviously just cover corruption. It covers all sorts of systems and controls. And although the FSA do not have the power to prosecute you criminally for corruption, certainly not at the moment, as John said, that whole debate is up for grabs at the moment. The turf war of who's going to bring the most corruption cases is up for grabs. Many people think that the FSA's way of prosecuting corruption cases by civil enforcement, as in the Aon case, is a much more effective way of supervising business. The SFO, who has jurisdiction to prosecute corruption internationally, although they do also take jurisdiction for serious domestic corruption, is taking a different line, or effectively has been forced to take a different line. Its initial stance, and we saw it with the early cases like Balfour Beatty, was to try and encourage the corporates to settle corruption cases in a civil way. In fact, the Crown Court judges have put the kibosh on that and have said that's not really the appropriate way to deal with corruption cases. Corruption is very serious. The starting point for a serious corruption case is in the Crown Court with criminal penalty. And I think that's a very important change in tone. And I think it's something that those in the regulated sector and those outside of the regulated sector need to take very seriously. Just closing that triumvirate, the City of London Police are, generally speaking, have jurisdiction for corruption cases in the UK, and they've certainly got a number of serious corruption cases on at the moment. And the reason why I say you're facing a double whammy is because if the FSA don't get you, then almost certainly the SFO will, and there's certainly a serious risk to you that they'll both get you, and then the DOJ will come after you as well. So, it is something not to be scared about, but obviously it's something that needs to go up to the top of the agenda, and for the board and those people leading and in the middle of your business in particular to take very seriously. So, I don't want to repeat what others have said, but I do think it's worth just reading once again Section 1 and Section 2, and then looking at Section 6, the foreign public official offence, because the wording is important, and there is a certain amount of hysteria building about the Section 6 offence in particular. And I want to try and allay some of those fears, certainly in the context of gifts and hospitality, which is what I'm mainly talking about this morning. So just turning to the Section 1 offence, which is the active giving of a bribe. So paying a bribe, Section 1, it will be an offence to offer or give a financial or other advantage, so that includes Chelsea Flower Show, lavish lunch, football, God forbid, more of a punishment than a bribe, but anyway, with the intention of, from my perspective, with the intention of inducing that person to perform a relevant function or activity. So you've got the two key elements there. You need to intend to induce improper conduct. Improper conduct's very widely drawn, and my personal view is we'll need to see some cases coming out perhaps before we really understand what that means. Section 2, drafted in a very similar fashion. It's the passive offence of receiving the bribe, and it will be an offence to receive a financial or other advantage, intending again, so you've got the intention again, that a relevant function or activity should be performed improperly. So you have to have an intention, either giving the bribe or receiving the bribe, and it needs to induce improper performance. Now, as I said, there's been a lot of talk about whether that now means a solicitor taking a client out for lunch is improperly influencing that client to give her legal work that she might not otherwise get. My personal view is that businesses need to be sensible and take a robust view in this line. I think they need to take comfort from the government guidelines and from the SFO policy statements. What the government says is that the legislation should not be used to penalise legitimate or proportionate hospitality, including in respect of foreign public officials. And I'll come on to that separate test in a minute. But as an issue, it is best governed by prosecutorial discretion. And I'll come on to why I think the government has left the issue of corporate hospitality in the hands of the regulator. But clearly, I think you have to look at the statute, intention to induce improper performance, and then you have to look at the stated policy of the government and the stated policy of the SFO, which is not to harm legitimate business, entertainment, hospitality and gifts. But what it does mean is you as a business have to be much more clear about what your risk is, who are the people who are giving, who are the people who are receiving hospitality. I think you need to be much clearer about where you're operating and what the norms are in those jurisdictions. I'll come on to talk in particular about sales promotions and factory visits and that kind of thing in a minute. But I also think that you clearly are going to have to monitor these things much more carefully. And certainly my business, we monitor business development, as we call it, marketing, hospitality, purely at the moment from a financial point of view. So if you're spending too much money, if you've exceeded your hospitality budget, you get a rap on the knuckles, in my case from an accountant, who tells me off for not getting the proper authorities or for spending too frivolously. So in a way, all business is going to have to do is to add something to the procedures that you already have in place for monitoring how your people perform. But it is really important that you understand what is going out of your business in terms of gifts and hospitality and what's coming in. And increasingly, you need to be explaining why you're engaging in these activities. Okay? I'm not talking about an elaborate business case every time you want to take someone out for lunch or to have them in your office for some training and a breakfast or anything like that. But I am saying that as an organisation and through training and through leadership, you're going to have to be much clearer about why you're doing these things, when you shouldn't be doing them, and whether you want to have ceilings on them, whether you want to have a cap, which, as my colleague said, can work perhaps domestically, but it's much more difficult to have, say, a €150 limit when you're operating globally. So those are the kind of things that you're going to have to be thinking about on a practical basis.